Hello and welcome to Immigration with Andrew. Today is June 20th, 2024, and in today's video I will be discussing the recent announcement from President Biden about the Parole-in-Place program for certain spouses of U.S. citizens. Great, so this announcement came out 2 days ago. I'll drop a link in the comments section with the fact sheet that was released. We don't know too much yet, but I thought it was worth doing a video to explain what the process is for these folks now without the benefit of this parole program, and then talk about what this parole program is going to do, and also what it's not going to do. A caveat here, I'll probably mention this again in the video later on. There is nothing to do yet. There's no form, there's no fee, there's no procedure, there's no application, there's nothing to do yet. And it could be challenged in the courts. Obviously we have elections again in November, so who knows what will actually end up happening with the program, but I thought it was worth doing a short explainer on parole in place, adjustment of status, unlawful presence, and these sorts of topics. So I want to start by saying what the process is for these folks now without the benefit of this program. So if someone is in the United States and they're married to a citizen, the first step in the process is always the same. The first step is to prove that the marriage is real, to prove that the couple got married for purposes of love and not for purposes of immigration. And so that's done on Form I-130. That process is taking approximately a year, but that's the first step in any sort of case, based on a family relationship anyway. And so if the person is in the United States without permission, and there are a couple exceptions that we're not going to get into, but generally speaking, if someone entered the United States without permission or can't prove that they came with permission, then generally they cannot get their green card in the United States. They cannot apply for their permanent residence in the United States, which means they would have to go back to their home country outside of the United States. And so there's a different law that says that if the person has been in the United States without permission for more than 1 year, and then they leave, for example, to attend their visa interview in a consulate abroad or an embassy abroad, once they leave, they cannot come back to the United States for a period of 10 years. And so there's a waiver for that. Unlawful presence bar is what we call it. But to get that waiver, the person would have to show that the spouse or parent, but the spouse would suffer extreme hardship if the person is either stuck outside the country for 10 years apart from their spouse, or the spouse goes back to their country to be with them and the spouse suffers extreme hardship there. It's extreme hardship to the spouse, to the citizen spouse. And those waivers right now are taking approximately 4 years. And so that, I think, is one of the purposes of this announcement the other day, is to alleviate that step. So if the person is in the United States and came with permission, doesn't matter if the person came legally, like on a tourist visa is probably the most common, student visa, work visa, whatever. The person comes on a visa and then just stays longer than they're allowed. If they're married to a U.S. citizen, then they can still apply for their green card in the United States without having to leave, without triggering that unlawful presence bar, without needing the waiver, without having to wait those 4 years for the waiver. And so what this parole in place is going to do is, again, if it exists, if it exists, will allow the person to apply for their green card in the United States. That's, I think, the bigger idea. Parole in place, parole itself, it's not like parole in the criminal world where you're in prison or jail and then you get out and you have a parole officer. It's the same word, it's a totally different thing. Parole in the world of immigration, it's a kind of status to be here. It's a way to enter the United States without a visa. And so it's maybe not worth getting into the complexities of that. But the point is, with the benefit of this program, the person's married to a United States citizen, they get this parole. It's called parole in place because the person's not actually leaving the United States to come back with parole. But the point is, if the person gets this parole, they're married to a citizen, they can apply for their permanent residence in the United States. Again, without having to leave, without triggering that unlawful presence bar of 10 years, and without needing a waiver for that, without needing to show extreme hardship to the spouse or anyone, and maybe most importantly, without having to wait approximately 4 years just to wait adjudication of those provisional unlawful presence waivers right now. So it's a big deal. It is big news. It's all very new. Again, this only came out 2 days ago. So what will happen now, what they say anyway, is that they will publish a notice in the Federal Register. It'll go to notice and comment, 60, 90 days, who knows, after that comment period, who knows how long it'll take to actually like publish the final rule and create the procedures, create the form, or create the instruction of the form, set the fee, and start accepting applications. State or the government could be sued. There could be an injunction. I don't think there'd be a restraining order, but the application or the procedure could be blocked. So we'll just see. So a lot of it is up in the air, is my point. So we don't know. We'll have to wait and see, unfortunately. But it is big news, and it should help a lot of people, again, if it comes into existence. A couple points I wanted to make at the end here. Number one, the program now is only for people who are married to U.S. citizens as of June 17th. And that, I assume, is because that if the person is in the United States, if the immigrant is in the United States, married to someone who only has a green card, then to apply for the green card in the United States, that person has to have maintained their non-immigrant status since their entry. So if they came on a student visa, they have to still be in that student status, or if they came as a visitor, they have to still be a visitor. And so it's just not going to make sense if you're married to a permanent resident. The other note is one of the requirements is that the person has been in the United States for 10 years, back from June 18th of 2024. I assume that they're going to need evidence of that. So bank statements, leases, bills, utility bills they like, medical records, religious organization records, school records, anything like that. But by definition, these people are undocumented. So how easily they can obtain some of these documents for 10 years, I think, remains to be seen. And then the other thing I wanted to point out is, and I can highlight it in the announcement too that I'll post, but above the actual list of requirements, it says in the paragraph above that the person is otherwise eligible to adjust. And so to me, it's not clear. Again, we're just going to have to wait for the rule and wait for the instructions. But to me, it's not clear whether that person needs to have that first step approved, that I-130, that marriage-based petition, already approved, because that's what a person would need in order to file for their adjustment, in order to file their green card application. So again, a lot up in the air. Those are the points I wanted to make. Stay tuned. I may or may not do another video when we get the final rule, although when the notice and comment period opens up, I'll try to amend the comments to post a link. If you want to leave a comment in the Federal Register on the program, they'll read it. So thanks for your time. Thanks for watching. Let me know if you have any questions in the comments below. Thanks a lot.